Your Honor, this is Reed Campbell. For defendants, I can hear you as well.
Good, good. We'll get started in just a moment. One kind of housekeeping matter, given some timekeeping issues, I'll keep track of time. And if you see a bailiff sort of pop up on the screen, that means you have 5 minutes left. All right. So, but keep track of your own time as well. And we'll call the case just now and get started. Now let me look here. Mr. Campbell, did we? Yeah, I think. Oh, we lost. Yeah, we lost Judge Swan. There he is.
There I am.
All right, good. All right, this is a time set for oral argument. In our case number is CACV 190420 Anderson versus Union Pacific. Counsel, good morning. We are conducting these proceedings obviously remotely on Zoom. We're recording the proceedings. They'll be posted later and in due course. So please, when you begin your presentation, tell us the name and the party that you represent. Each side does have 20 minutes. If appellant wishes to reserve a portion of that time for rebuttal, you're free to do so. But Mr. Rabb, you need to keep track of your own time, and I'll be keeping track of time as well. We have reviewed your briefs. We're familiar with the record. We've conferenced the case. We'd encourage you to keep that in mind as you do present oral argument to us today. With that, Mr. Rabb, you may proceed.
Thank you, Your Honor. May it please the court, Mr. Campbell. My name is Matthew Rabb, and I represent the appellant Brandon Anderson. And first, I'd like to apologize. I'm not quite certain of the formalities that should be followed in this video conference argument. I'll assume that they are the same formalities as if we were in the courtroom. I would like to reserve 7 minutes of time for my rebuttal, so I'll get to the issues quickly here. Mr. Anderson brings to this court 5 issues. 3 of them evidentiary, 1 implicates privilege, and 2 of them regarding a jury instruction. Each of these errors deprived Mr. Anderson of a fair and impartial determination of the case. And because we have limited time, I will begin with the most egregious error. This error and this court's decision regarding this issue has statewide implications about the future of the mediation privilege and participation in ADR in Arizona. Specifically, the trial court admitted evidence of statements made at mediation because the trial court determined that plaintiff waived the privilege because his objection at the video trial deposition was based on hearsay and not privilege.
Well, counsel, this is Judge Howell. What makes the mediation privilege any different than any other privilege? Any other privilege can be waived by not raising it timely or properly.
Thank you, Your Honor. The difference is the mediation privilege is created by statute and has no common law basis.
So is the attorney-client privilege.
I'm sorry, Your Honor, I couldn't hear
So
you.
is the doctor-patient privilege. I'm sorry, can you not hear me?
I can hear you now, yes.
Okay, the attorney-client privilege and doctor-patient privilege are both created by statute, and if somebody asks for attorney-client privilege information at a deposition and there's no objection or instruction not to answer, that privilege is gone. So I don't understand why it would be different for this privilege.
Because there is a basis in the attorney-client privilege and the patient-physician privilege in common law. There is no such basis for the mediation privilege, as this court said in Gruba. In Gruba, this court said that the only way to waive the mediation privilege is listed in the statute, and those waiver provisions are specific and exclusive.
Well, counsel, I think you're misreading group law, because in group law, the issue is, there's a filing of that particular lawsuit waive the privilege, and the court in group law said no, that merely filing the lawsuit does not waive the privilege. That's a different issue. And for the failing to raise it is a waiver.
The the way as I understood it in Grubaugh, the defendant asserted that, or asked the court before disclosure and discovery began, he asked the court to either find that the privilege was waived, or in the alternative, to strike the portions of the complaint which relied on statements made during mediation.
But Grubaugh found that the filing of a malpractice claim by one party to a mediation against third parties did not by itself waive the privilege. So the issue in Grubaugh is whether the filing of the action constituted a waiver of the mediation privilege. And that isn't what we have here.
That's correct. That is not what we have here. But I also think the court needs to focus on the portion of the statute, the privilege statute, that says that this is not discoverable nor admissible.
I'm looking at the statute right now, and I'm not seeing instructions on how to waive the privilege written by the legislature. What language are you saying preempts the field of waiver?
Sure. The portion of the statute that provides the specific waiver is, it says, admitted into evidence unless one of the following exceptions is met. And then it has 4 exceptions, none of which apply in this case.
Well, but those are exceptions to the attachment of the privilege. They don't deal with waiver. I mean, one might say in the attorney-client privilege context, there has to be an attorney, there has to be a client, there has to be a relationship between those two, and there has to be a covered communication. If those don't apply, there's no privilege. But that says nothing about how you waive the privilege once it attaches. And here, there's no reason ever to make a hearsay objection at a deposition. Those are not waived, but there is a need to make a privilege objection. And the cat was out of the bag for quite a while before anybody raised even the bare existence of the mediation privilege. So I'm struggling to see how you get past that.
But you're right, the cat was out of the bag, and we couldn't stop it because it was a statement made just like that. It was.
Well,
I'm sorry.
But I mean, that was a moment to say, "Hey, wait a minute. Sure, the statement was made, but then you say, excuse me, but that's covered by the mediation privilege," and no one did that.
But as Judge Swan said, the cat was out of the bag. We weren't at that point. We weren't trying to prevent the disclosure of the statement. At that point, we needed to prevent its admission into evidence.
Well, but wait, if it's a privilege, it's the same thing. I mean, you can't just go disclosing willy-nilly and then invoke the privilege. You couldn't do that with attorney-client or doctor-patient. Even if the cat gets partially out of the bag, you've got to struggle to put the cat back in the bag before it runs down the street. And I don't.
Sorry. Once it was out, we made our objections in the pretrial statement. We made our objections again. Once it was made, we couldn't stop it from coming out. Once she said that, I don't know if it would have made a difference if we then objected to privilege after she had already said it.
Isn't that how things normally work? Someone says something that you believe is objectionable, and then you object to it. And you say it's objectionable under the mediation privilege, but you didn't raise your objection.
Well, we didn't raise the objection immediately after she made it. We did raise the objection in our pretrial statement. But if we read the statute, it's also an evidentiary statute, not just a disclosure statute. So even if that evidence was out, the statement was out, then the court still shouldn't have let it in. And the narrow reading that the trial court gave it, I think wasn't exactly considered by the mediation privilege statute. I would like to.
Well, counsel, would you clarify something for me? I understand from the record that you didn't raise the privilege objection into moving to reconsider the denial of the motion in limine. So there was a lot of time and water under the bridge before you raised the privilege objection.
I'm not sure how much time had passed from the video trial testimony deposition to our objection in the pretrial statement. The case got delayed several times.
Well, here's an example. Did you advance the privilege argument in your motion in limine?
I don't believe it was included in the motion in limine. It was included in the pretrial. But motions in limine, I believe, were submitted before, right around Ms. Hull's testimony. But like I said, I think it's important to focus on the statute's language. It says that it shall not be discoverable or admissible.
So, counsel, is it your point that you could never waive that protection? Is that what you're arguing?
No, Your Honor. My argument is that it can only be waived according to the statutory provisions, the statutory exceptions.
And so, just to give you another hypothetical, let's say the objection didn't come until after the close of the evidence at trial. You're saying that would still be timely?
No, because at that point the objection would have been the evidentiary objection would have been waived.
But that's not something that is contained in the statute, right?
No, that is not something contained in the statute. That's, I believe, that objections not made at the time of the testimony are waived.
So a 104, 105 rule of evidence sort of waiver as opposed to a statutory waiver.
Yes, Judge.
Okay.
Now I'd like to discuss why this statement was prejudicial. It was prejudicial not just because it was confidential and Mr. Anderson did not expect it to be used against him, but what Ms. Hull said was, while at mediation, Mr. Anderson said he wouldn't have to worry about working, that he wouldn't have to work ever again in his life, basically because we have issues of child support and him paying, that he would be getting a settlement from the railroad where he would never have to work again. This statement says two things. It says this guy doesn't pay child support and he thinks he's going to get rich because of this lawsuit. For what issues were these statements relevant? None. So what was the purpose of the question?
Well, counsel, the court gave a jury instruction on how they were to consider her statements. And the jury's presumed to follow their instructions.
The court gave that instruction to the jury regarding Ms. Hull's opinion of Mr. Anderson's specific testimony, not regarding the statements admitted at mediation. And so the prejudicial effect was, the purpose this was admitted is defendant asked her, has Mr. Anderson told her anything about what you expect to gain from this lawsuit? And that's when she responded about the mediation statement.
Well, counsel, I thought the court instructed the jury that it could consider Hull's testimony only to the extent it shows Hull's reason for contacting the defendant. That means that any other use that could be posed by the testimony shouldn't be considered.
Thank you, Your Honor. That goes to the second issue that we raised in our opening brief regarding the opinion she gave regarding his specific testimony. That was not for the mediation statement.
Well, but the instruction seems broad enough to include everything. Am I wrong?
I believe you are wrong, because that limiting instruction. I have the 7 minutes that I would like to reserve left. Would you like me to answer the question, Your Honor?
Counsel, why don't you proceed with the answer to that question?
Okay. It was not broad enough, and it did not include the mediation statement because that limiting instruction was given specifically regarding the opinions of Ms. Hull's testimony as they relate to the specific testimony of Brandon Anderson. And then that instruction was again, that limiting instruction was again given in the final instructions to the jury. Again, a reference to only the opinions regarding his testimony. Thank you, Your Honors.
Very well. Mr. Campbell.
Yes, thank you, Your Honor. Good morning. My name is Reed Campbell, and I represent Union Pacific Railroad Company. Let me just jump straight in to this mediation issue. In addition to the waiver issue, it's not clear that this statute even applies to these communications. Union Pacific acknowledges that certain communications do fall under this statute, but the record before this court is insufficient to conclude that the statement from Mr. Anderson to Ms. Hull would meet that statutory requirement.
If that statement doesn't meet the requirement, what does?
Well, it's just the actual statement itself is not relevant. It's the plaintiff is relying solely on the phrase "at mediation," which is ambiguous.
Well, if it's not relevant, why was it offered and admitted?
What's that?
I know what you're saying. It's not relevant to the mediation, but somehow it was relevant to this case. I mean, it seems to me that the relevance of these is tangential at best, and we need to look at it both to determine if there was error and if that error was harmless. But I'm not seeing the relevance to the case, and I'm certainly seeing the relevance to the mediation.
Well, as far as the relevance to the case, the plaintiff never objected to that testimony based on relevance.
That's not what I asked. I asked, why is it relevant? Let's say that we were at trial now and there was an objection. What would you say?
Well, the question that was asked was, has he told you anything about what he expects to the lawsuit? And the plaintiff's statements regarding his case can certainly be relevant.
I mean, all he's saying is, I've got a big lawsuit and I'm going to win it. Who cares? Everybody feels that way when they file a lawsuit.
And Your Honor, I think that point is exactly why there's no prejudice in this case. That's something that the plaintiff told the jury in opening statement, that I need a multi-million-dollar verdict because I can't work anymore. That narrative was advanced in the plaintiff's direct examination and through all of his experts, and also in his closing. So there's, even if it's not relevant, which wasn't objected to, it certainly is not prejudicial.
Okay, well, let me ask you this. Taking your prejudice point and setting it to one side, do you think it was relevant?
I think the question was relevant. And, oftentimes a witness in a trial will give some portions of an answer that just don't really address the question and aren't necessarily tied closely to what is relevant. But that's an objection that should be made in a motion to strike that particular section of the testimony based on relevance, which wasn't done here. The only objection at the time of the testimony was hearsay, which it would be considered an omission, potentially an omission against interest, depending on what he said. And then later on, this mediation objection based solely on the phrase "at mediation," which in order for the statute to apply, it has to be during the mediation process, made in front of the mediator, and that's the only time it's made. You can't go out of the mediation and say it to someone else and still expect that later statement to be confidential. And by not raising that issue at the time of Ms. Hull's trial testimony, it prevented the defendant, Union Pacific, from exploring the context of that statement further, whether it was stated other places, and really what she meant at mediation. And in addition to that, all of these circumstances of whether these statements apply to the mediation privilege are supposed to be done by the trial court. In that case that plaintiff cited, the Colombo case or versus Palomo, the court stated that these fact-based findings should really be done by the trial court and not done by the court.
I'm sorry. Is anybody else having trouble with freezing communications?
I am not, Judge Swan.
No, I'm not either.
Are you back up and running, Peter, or not?
I can hear you now, but I missed a good 45 seconds or so. I don't know if everybody else could hear.
We could.
And now you're all frozen again.
Okay. Can you hear now, Peter?
I apologize.
No, let me ask you, Judge Swan, can you hear us even if you can't see us?
I can't. Let me see. Sam?
Yes.
Hello?
Yes. Judge Swan, do you want to log out and then log back in and see if that
Anybody
helps?
hear me?
We can hear you, Judge Swan.
We can.
This is
Folks, we've hit pause on the timing, and let me take a short break here.
Is this better?
We can hear you, yes, Judge Swan. Can you hear us?
I just got to the point where I can hear you. I don't know if this disruption is all on my end, but I apologize.
No apology necessary, Judge Swan. I think it may be on just with your connection, but I'm glad you raised it. And Mr. Campbell, I will, and Judge Swan, you can hear us now, correct?
Yes, I can. Thank you.
Okay. Mr. Campbell, let me ask you to sort of go back about a minute's worth on your answer and to kind of bring Judge Swan and the rest of us up to speed, and then I'll start the clock again.
Okay.
Oh no.
Uh-oh, hold on. Judge Swan?
Yeah, I'm going to turn off my camera in hopes of consuming less bandwidth.
Okay.
Can you hear me?
We can hear you. Can you hear us?
Reasonably well.
Okay. Very well. Mr. Campbell, please proceed.
Thank you, Your Honor. As I was saying, is that, the decision that the plaintiff is asking you to decide today is that these statements are in fact covered by this privilege, and the record before you just doesn't get you there. It didn't get the trial court there. And as this court noted in the Grumbo versus Palombo case, quote, rather than this court undertaking to identify precisely the application of the mediation process privilege to specific communications, it is more appropriate to allow the Superior Court to make that determination.
Mr. Campbell, let me ask you on that point. The court, if I read the record right, though, denied the objection based on privilege, saying it had been waived, right? And then concluding that the information was relevant to the trial in this case. Don't we take the record if the court found that a privilege was waived? Doesn't that imply a finding that there was something that was privileged in it, or at least the statute did apply at some point, but that inaction or otherwise, the protection of that statute no longer had traction?
Your Honor, based on the court's ruling, I think that it's ambiguous on exactly what the court is saying, and that is something that plaintiffs should have brought an offer of proof to really expand on that at the court.
And I understand your point, but if your point is, hey, this court should defer to what the trial court did, as the and we do, take the case as the record comes to us, but a finding that a statutory privilege has been waived implies to me at least that there is at least a tacit finding that the statute that contained the privilege applied. So you're asking us to look at it sort of the opposite way, and I wonder how we get there. Well,
Your Honor, I actually think that you could look at it both ways. it's not just whether it was waived, but really the trial court's ability to evaluate the objection was hampered by the record that was brought before it, and then the record made at the time of trial.
Well, Kessa, aren't you creating difficulty for yourself when we really need to address this thorny issue? And I admit, from the question, it seems rather thorny if the matter is waived.
Well, it certainly is a thorny issue, but I don't necessarily think that there's enough evidence in the record to properly address it. And
are you maintaining that the privilege was waived, though?
Yes, the privilege was waived if it applied, and I don't even know if we get there, Your Honor. Before the court.
Would you rather argue whether the privilege applied and whether it was waived?
Would I rather argue?
Yeah,
I think both arguments are relevant. Certainly, I think that if before you determine that the privilege is waived, you should confirm that it does in fact apply. And when, as this court's noted in Bliss v. Treese, when the record is incomplete, a reviewing court must assume that any evidence not available supported the trial court's action. So I think that that in addition to waiving the privileges, if it exists, there's not enough evidence to even show that it applied. And then
Mr. Campbell, though, isn't though that presumption, which has traction in a lot of case law that this court is asked to apply, doesn't that assume, or doesn't that sort of direct us to find two things: that the Superior Court found the privilege could have applied, or maybe did apply at some point, but secondly had been waived? I mean, I understand your point, but if we're to fill in the gaps of what a record suggests, when a court finds that a statutory privilege was waived, I think that's tacitly or implicitly finding that it either did or could have applied at some point. And that's where I depart with your thought on the first argument.
I understand your position, Judge, and again, I would prefer to have a cleaner record to where the trial court had the ability to really explain that. But at the end of the day, what you are deciding is whether, if it did apply and that statement should have been excluded, whether that is prejudicial error, negating the jury's verdict and sending this case back to another 2-week jury trial. And really nothing that she said raises to that issue if it applied and if it was not waivable as plaintiff suggests. So I think that the argument the discussion we're having on whether it applies or not, while certainly interesting, is not determinative of this case and whether this case should be vacated and remanded for a second trial, Your Honor. I would just like to just briefly touch on a couple of the other issues, but if the court has questions more on this, I'm happy to stay here.
Please proceed.
Okay, thank you, Your Honor. With regards to his second claim regarding the truthfulness of the statements, the Rule 105 allows a limiting instruction. It was an appropriate use. It was given twice at the trial, and that is exactly the purpose of that rule, is to instruct the jury that this testimony is admissible for one purpose and not the other. Throughout the trial, plaintiff challenged her motivations. The reason she came forward is certainly relevant to her credibility and to defend against plaintiff's attacks. We ask trial courts to do these evidentiary evaluations all the time. The court's decision to issue a limiting instruction was not an abuse of discretion and not grounds for reversal. And in addition to that, there was no prejudice because Ms. Hull, her testimony went to causation on the back injury that plaintiff claims he suffered, and the jury just never got there. They never found Union Pacific negligent. And that finding would have been required under the FELA before you go look at causation and causation to the ankle injury, which was undisputed, and to the back injury. So Ms. Holt's testimony really had no impact on the jury's ultimate determination. And we know this because Union Pacific conceded causation on the ankle injury. So by finding completely for the defense without any award, we know that in the jury's analysis that they analyzed the duty and never found a breach. With regards to the third issue, the federal safety standards, the court followed precedent out of the 3rd, 4th, and 9th Circuit, which said that this evidence is admissible as evidence of the standard of care. It doesn't conflate or mislead the jury. It really just is evidence of whether Union Pacific's decision to provide a vehicle that complied with these standards was a reasonable one. And the jury ultimately concluded that it was. With regards to the last issue, the court did not commit reversible error when it offered jury instruction number 11. Jury instruction number 11 is not an unavoidable accident instruction as plaintiff's claims. It simply just restates that he must demonstrate negligence under the FELA before he can recover. And this is unique in the employee-employer workplace injury claims because most claims go through Arizona's workers' compensation statute where a negligence showing is not required. And so this is kind of the extraordinary case. The instruction does not conflate proximate cause and doesn't talk about proximate cause at all. It just reminds the jury that before he goes finding causation and subsequent damages, he needs to prove negligence, and the jury needs to find negligence before it moves down that analysis. Plaintiff's brief on this issue misinterprets the holding in McBride, which McBride established that there was a relaxed causation standard, not a relaxed negligence standard. You still had to prove negligence in accordance with the common law that Union Pacific failed to take reasonable steps to provide a reasonably safe workplace. And then once you do that, then if that negligence contributed in whole or in part to plaintiff's injuries, he's entitled to a recovery. And again, based on the jury's verdict, finding for Union Pacific completely, we know that the jury never got there. And so it just simply is not relevant to how the jury came down on this case. Finally, plaintiff's reliance on Camfield and Trickle are similarly misplaced because in those cases, although we don't have the benefit of the actual instruction, Justice Stuckmeyer noted in his dissent that the jury may seek to expand some particular significance to the word inevitable or unavoidable in the challenge instruction. And in the instruction that plaintiff challenges here, those concepts of inevitability are not contained in the instruction. It simply states, standing alone, the mere fact that an accident happened does not mean it was caused by someone's negligence.
Mr. Campbell, let me ask you, why was that instruction necessary?
Your Honor, I think it was necessary because juries often are unfamiliar with the FELA. When most people are injured at work, they go through the non-fault system of Arizona's workers' compensation statute, which doesn't have any negligence requirement. And so this was just reminding them that the FELA is different.
Let me ask you, though, I take your point, but isn't it fair to understand that most juries in a personal injury case, the common law negligence case, are unfamiliar with negligence, and that's why they're instructed, with the elements. And if they're instructed with a good and clear set of instructions on the prima facie elements of a negligence claim, I don't know that you would need to tell them this, other than to say, you know, to find for plaintiff, you must find all of these elements. So would the better practice have been to not give this instruction?
Your Honor, I think that the unique nature of the FVLA warranted that additional reminder that this is not a no-fault statute. But even if I take your point that this was unnecessary or duplicative of a prior instruction, that alone is not reversible error. As the court said in Bliss v. Treese, that repetitiveness alone does not constitute prejudice and reversible error. And in the Camfield case, that even if you did consider this unavoidable accident instruction or duplicative, you have to show prejudice to vacate the jury verdict and send this back down to the Court of Appeals, or excuse me, to the Superior Court.
Thank you, counsel. Anything else, Mr. Campbell, today?
No, Your Honor. I would just add that under the FLA, plaintiff must prove that Union Pacific was negligent before he can recover. And the jury determined that he failed to do this and that Union Pacific was not negligent. Nothing in his briefing provides a basis to disturb this jury's verdict. Thank you, Your Honor, for the opportunity to address you today in this unique setting.
Thank you, counsel. Mr. Rabb, you do have the last word, and I have you for about 6 minutes left, but we'll see if our bailiff has a different number. You may proceed.
Thank you, Your Honor. I would like to read briefly from Grubaugh to answer one of your questions. In Grubaugh, it says, in contrast to the attorney-client privilege, Arizona's mediation process privilege has no common law origin. It was created entirely by legislature. Therefore, this court must rely on the language of the statute to determine its meaning. Unlike the waiver of attorney-client privilege under the statute in common law, the statutory waiver provisions of the mediation process privilege are specific and exclusive. By expressly shielding the entire mediation process, other than when an exception provided by the statute applies, the statute occupies the entire field of methods by which the mediation process privilege might be waived. The statute therefore leaves no room for an implied waiver.
But I think that's what would be the issue in that case was filing the complaint an implicit waiver of the privilege, and that isn't what we have here. We have a different mechanism that if a party that doesn't raise a privilege, then the privilege is irrelevant. Well,
the question in this case is, does failing to object to privilege immediately after the testimony comes out waive the privilege?
When the answer would seem to be yes.
And counsel, let me ask, just to supplement Judge Howe's question, isn't that though a question of the rules of civil procedure and the rules of evidence, as opposed to a question of the statutory application?
I think in part, yes. In this case, though, this was unique because this was trial testimony, video deposition. That evidence we can stop that from coming in. And although objection was made for the wrong basis, objection to hearsay, I think we can still assert the objection in our pretrial statement like we did. And this issue hasn't been brought up by defendant, or this defense hasn't been brought up by defendant. Of note also is that defendant in its answering brief never answers the question regarding waiver. It never addresses waiver. Real quick, in Hawkins, our Supreme Court specifically said that when prejudicial evidence is admitted, if you remember in Hawkins, I'll back up real quick, there was hearsay evidence that was admitted that goes directly to the believability of a indispensable witness, I guess I could say. And if that inadmissible evidence tended to destroy that credibility, even if it only went to damages, then the issue of negligence, which the jury found for a defendant, the admission of that testimony was erroneous and must be held to be prejudicial error. So even though Ms. Hull's testimony went just to damages, her attacks, her colorful attacks, calling Mr. Brandon Anderson's testimony deceitful, blatantly wrong, makes you sick, that tended to destroy his credibility. And he was the key witness in the negligence case because he was the only witness to the incident. And a fact of which the defendant brought up to the jury. And so that inadmissible testimony tended to destroy his credibility and is therefore prejudicial error, according to Hawkins. Regarding the admissions of the FMVSA, SAE standards, and Ford standards, Mr. Anderson brought suit under the FELA. That act imposes a non-delegable duty on Union Pacific to exercise ordinary care to supply machinery and equipment reasonably safe and suitable for the use of the employee in the railroading environment. So the jury had to answer the question, was the truck reasonably safe for UP to put in use, not whether it was safe as manufactured. And when the court let in those three, that the truck met those standards, it abused its discretion. Now, those three standards weren't relevant at all. The FMVSA's purpose is to reduce traffic accidents and deaths. Mr. Anderson was not injured in a traffic accident. There was, and of note, I reviewed Mr. Paddock's testimony again and didn't see in the record that he testified as to any specific standard. Rather, he testified generally that this truck met all three standards. And defendant points to OSHA and the admissibility of OSHA regulations to establish a standard of care. But I think what's important to note is that OSHA concerns an employer's conduct. Therefore, it's relevant. The standard that was applied by these three entities, was of and concerning a third party's conduct, basically Ford Motor Company. Defendant cites to Holenkamp and says that manufacturing standards are admissible as evidence of standard of care. That's not what Holenkamp said. Holenkamp holds that industry standards are admissible. And in our case, industry standard would have been the railroad industry, not the car manufacturing industry.
But if you had a report, I don't know if you can hear me, but if you had a report that said this vehicle did not comply, I imagine you would think it very relevant.
I would think that it would be relevant, but I would point to a specific standard. That's not what happened in this case. They didn't point to a specific standard that it complied with. They just said it complied with everything. Finally, the jury instruction. First, I'd like to say that regarding prejudicial, how prejudicial all these evidentiary issues were. The defendant several times in its answering brief said that the court shouldn't disturb a unanimous jury verdict. This jury verdict was not unanimous. It was 7-3. It was one juror away from a different result. And although that misrepresentation was probably unintentional, if appellee believes that a unanimous verdict was significant, doesn't it reason that a 7-3 verdict is also significant? I think I'm all done with my time, Your Honor.
I think you are, Mr. Rapp. Thank you, counsel. We appreciate your briefing. We appreciate your presentation here today. We will take the matter under advisement and we will issue a written ruling in due course. So thank you. Court is adjourned. You're free to leave at this time.
Thank you, Your Honors.